Please be seated. The sitting is open. La Cour se réunit ce matin.
The court meets this morning to hear Colombia, Cuba, Egypt, the United Arab Emirates and the United States of America on the questions submitted to it by the United Nations General Assembly on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. I would kindly recall that each delegation must respect the time allocated to it for its presentation, namely 30 minutes. The court will take a short break this morning after Egypt's statement.
To the representative of Colombia and invite Mrs. Andrea Jimenez Herrera to address the court.
Mr. President, members of the court, it is a great honor for me to address the court on behalf of the Republic of Colombia in these proceedings. Our presence here today bears witness to Colombia's tradition of respect for international law, but it also reflects Colombia's deep concern about the incidents that regularly occur between the State of Palestine and the State of Israel, exacerbated after the horrific events taking place since 7th October 2023, which have unleashed a cycle of violence that has only worsened an already calamitous situation, causing the death of more than 27,000 civilians and thousands of wounded. Colombia rejects any recourse to violence or unilateral acts that lead to a higher level of confrontation. We also believe that holding states accountable for violating international law, especially when their actions bring about dire humanitarian consequences, is a sign of respect for the rule of law. Colombia has expressed before and reiterates today that the occupation of the Palestinian territory is a violation of international law and is contrary to the principles enshrined in the Charter of the United Nations. Furthermore, as the court itself stated in the construction of a wall opinion, it is clear that both Israel and Palestine have the obligation to abide by international law and to respect and ensure respect for international humanitarian law and human rights law within the occupied Palestinian territory. Both states also need to implement in good faith all relevant Security Council and General Assembly resolutions. Additionally, Colombia fully shares the court's view in its advisory opinion on the construction of a wall to the effect that the United Nations and the General Assembly in particular need to redouble efforts to encourage a negotiated solution to the outstanding problems on the basis of international law and with the purpose of the establishment of a fully viable Palestinian state existing side by side with Israel and its neighbors, fostering peace and security in the region. Nearly 2 decades after that landmark decision was issued, and in light of the gravity of the current situation in the occupied Palestinian territory, the advisory opinion to be rendered by the court in these proceedings shall provide much needed guidance to the UN system and third states in order to continue supporting both states reaching a solution through dialogue and based on mutual respect. Colombia thus considers that through its advisory opinion, the court can contribute to clarifying the law, especially the rules governing the consequences of violations to peremptory norms of international law, namely rules of jus cogens and erga omnes obligations, and to specific legal regimes which are the concern of all of mankind. Mr. President, I will begin by referring to the issue of the jurisdiction of the court to render the requested advisory opinion. By virtue of Article 65, Paragraph 1 of the Statute of the Court, 2 requirements must be met for the court to have jurisdiction to give an opinion. 1, There must be a formal request from a body duly authorized by the UN Charter or in accordance to it to make such a request. And 2, the question put before the court must be a legal question. It is undisputed that the General Assembly is one of the bodies authorized to make such a request in line with Article 96, Paragraph 1 of the Charter, and that the decision of the General Assembly to submit the questions contained in Resolution 77/247 was adopted in accordance with its rules of procedure and by the required majority. A significant number of states, member states, including Colombia, decided it was important for the General Assembly to receive guidance on the questions put to the court. Therefore, the request observes the first requirement. The second requirement, namely that the question put before the court be a legal one, is also complied with in the present case. Indeed, in your jurisprudence, particularly, for example, in the Nuclear Weapons Advisory Opinion, you've clarified that a question is a legal one when, and I quote, the court is asked to rule on the compatibility of the request with the relevant principles and rules of international law, end of quote. In other words, questions framed in terms of law and raising problems of international law, whereby the court is asked to identify and apply principles and rules of international law, qualify as questions of a legal character. Colombia considers that the questions raised in Resolution 77/247 are indeed framed in legal terms, since they request the court to determine the legal consequences arising from the policies and practices of the State of Israel, a member state of the United Nations, in the occupied Palestinian territory, including East Jerusalem, and to ascertain how those actions affect the legal status of the occupation. Those questions are to be answered through the application of rules of international law and therefore constitute legal questions which could form the basis of a request for an advisory opinion. Thus, in the opinion of Colombia, the court has jurisdiction to respond to the questions contained in Resolution 77/247. Mr. President, I will now focus on the question of propriety. In this respect, while Article 65, Paragraph 1 of the Statute of the Court gives the court discretionary power to give or not an advisory opinion that has been requested from it, in its case law, the court clarified certain important points, namely, first, that the court may give an advisory opinion should be interpreted to mean that the court has always a discretionary power to decline to give an advisory opinion even if the conditions of jurisdiction are met. And second, the court is always mindful of the fact that its answer to a request for an advisory opinion represents its participation in the activities of the organization and, in principle, should not be refused. While certain states have expressed opposition to the request by the General Assembly, the reasons argued are, for the most part, quite similar to those dismissed by the court in its advisory opinion on the construction of a wall. In that case, the court decided to render the requested opinion as, in its own words, and I quote, differences of views on legal issues have existed in practically every advisory proceeding, end of quote. Colombia posits that the court's thorough reasoning then, soundly grounded on its long-standing jurisprudence, is directly applicable to the current request. Consequently, Colombia considers that the court should reach the same conclusion in the present proceedings. That is, that it can and will exercise jurisdiction, and that there are no compelling reasons for it to use its discretionary power not to render an opinion. Hence, Colombia invites the court to pronounce the law on the legal consequences arising out of serious breaches of peremptory norms of general international law and thus assist the General Assembly in the proper exercise of its functions, the United Nations in discharging its responsibilities in this matter, originating, as the court recalled, in the mandate and the partition resolution concerning Palestine, and all states who possess an interest in the protection of erga omnes obligations. Mr. President, an additional important circumstance that should be factored in by the court when deciding as to the propriety of rendering its advisory opinion is that the situation in the Palestinian occupied territory has changed drastically since the request was transmitted to the court in January 2023. On 7th October of the same year, Israel was the victim of a horrifying attack by Hamas. We all know the scale and the magnitude of Israel's reaction to the attack. The court itself has already been confronted with the veritable map of horror and devastation which the Gaza Strip has become as a result of the total war and scorched earth policies unleashed by the government of Israel. Indeed, in several passages of its order of 26 January concerning provisional measures in the case brought by South Africa against Israel on 29 December 2023, the court took judicial notice of some details of this dire situation. To quote just one of such passages in the court's own words, the court considers that the civilian population in the Gaza Strip remains extremely vulnerable. It recalls that the military operation conducted by Israel after 7 October 2023 has resulted, inter alia, in tens of thousands of deaths and injuries and the destruction of homes, schools, medical facilities, and other vital infrastructure, as well as displacement on a massive scale. The court notes that the operation is ongoing and that the Prime Minister of Israel announced on 18 January 2024 that the war will take many more long months. At present, many Palestinians in the Gaza Strip have no access to the most basic foodstuffs, potable water, electricity, essential medicines, or heating. End of quote. Evidently, the factual matrix of that case and the background of these advisory proceedings are not identical. And in particular, the request by the General Assembly has a wider scope than South Africa's application in at least two respects. One, in that the requested advisory opinion refers to the policies and practices of Israel in the whole Palestinian occupied territory and not only in the Gaza Strip. And two, in that it covers all actions that Israel carries out in such territory and not only the actions and omissions by state agents that, according to the applicant in the contentious case, amount to genocide. But the point remains that those policies and practices, which in Columbia's view contravene essential norms of international law, have taken a turn for the worse as a result of Israel's military campaign unfolding in Gaza. Today, a place of death and despair that, in the words of an impartial source, has simply become uninhabitable. Colombia respectfully submits that the court should not underestimate the fact that the situation in Gaza has become more deadly over the past months, and therefore the legal consequences of such actions must be even more serious today than in the world we were living before this bloodshed started. Against that distressing background, and for all the reasons explained above, the government of Colombia, in line with its policy of pursuing total peace both within and beyond its borders, calls upon the court to avail itself of the opportunity to clarify legal aspects that may pave the way for the parties to resume a fruitful